Good morning and welcome to the annual meeting with the Bar. We are coming to you live from Atlanta, Georgia, home of the world champion Atlanta Braves. That sounds really good, doesn't it? We may have fewer attendees at this meeting because of the parade, which is starting later today, but as usual, we are recording this event and the PowerPoint both will be posted to the court's website early next week. The Q&A feature for this Zoom meeting is enabled, so you're welcome to ask questions during the presentation. Several of our great clerk's office team members are online and will answer questions as they come in. Please remember that your questions are visible to all participants. At the end of the presentation, you will be able to ask questions aloud, and I will do my best to respond. If I don't know the answer, I will find out and get back to you after the meeting. And also remember that throughout the year, anytime you have general questions, you can send them to info@ganb.uscourts.gov. So let's begin our presentation. Normally at this time, when I talk about statistics, it's for the period ending September 30. And because we're having this meeting a week earlier than normal, I don't have those statistics back from the administrative office yet. So we are using the June 30, 2021 statistics, the 12-month period ending that date. As of that June 30th date, Georgia Northern was the 5th busiest bankruptcy court in the country with just under 15,000 cases filed. Normally we're number 3 or number 4, but you're probably the last people I need to tell that filings are down and they haven't bounced back during the end, hopefully, what's the end of the pandemic as we had thought they might. So 15,000 cases in a year is very low for our court. All courts are experiencing some degree of that kind of filing decline, but we'll see what happens in the coming months. We are still number 1 in Chapter 13 filings, but that number is considerably smaller than what is normally a year's worth of Chapter 13 cases. For filings per 100,000 people, we are the 18th highest in the country with 2.11% of cases being filed. Alabama Middle actually took over the number 1 spot, and they have a 3.96% rating. And for pro se filings, we are 22nd highest in the country with 5% of all of our filings coming from pro se parties. So just a little bit about the fiscal year 2022 budget. As what has become usual, we are under a continuing resolution through December 3rd, 2021. There has been a lot of discussion lately, as I'm sure you've heard and read, about reconciliation and budgets coming out of DC. We'll see what happens. The thing for us to remember in terms of court operations is that the judiciary does maintain funding from non-appropriated sources, so from monies that don't come from Congress, and that's generally filing fees. So there are funds available to maintain judiciary operations for a limited period of time. They tell us approximately 2 weeks, but even after that runs out, if we're in a partial government shutdown, Georgia Northern will be open for business. We will not close the court. A little bit about COVID and the court, and last year I think we spent a good bit of time in this meeting talking about protocols and changes and things like that, but we've kind of fallen into a more normal COVID, as normal as that can be, situation. Meetings of creditors, as you know, continue to be conducted telephonically. While we have not received anything official from the United States Trustee Program, the word on the street is that that may be a permanent change in their operations, that they will be conducted telephonically or by Zoom going forward. As soon as we receive any official notification of that, we will let you know. For calendar calls and hearings in the court, they are being conducted telephonically, via Zoom, or in a hybrid fashion. But please continue to check each chamber's webpage for specific information. We did, in the last month or two, successfully migrate from WebEx to Zoom for Government for our court proceedings. A couple of things that we'd like to share as best practices to make those as successful as they can for all participants. One is for you to use, we recommend that you use a headset. That will cut down on the feedback between the microphones and the speakers on your devices. Also try to minimize any outside noise. That includes your phone, of course, ringing, text message alerts that come through, or any other device that makes a sound while you're in a court proceeding. And I think the biggest thing, and the one over which we as the court don't have any control, is your Wi-Fi connection. Most of the times when we're made aware of a problem during a hearing, in terms of connectivity, it's not from the court side, it's because the participant, someone of a participant doesn't have a good, strong Wi-Fi or stable Wi-Fi connection. So I know it's the world we live in now, but I would just say to please make sure that your connection is strong. If where you are, it is not strong, to go to a place where it is. Or if you just don't think you're comfortable maintaining that kind of connection, contact the court. They may decide to do it in-person hearing or take some other action. In terms of court staffing and operations, as you know, we never closed the court, any location during COVID, as some courts had to do. There were occasionally a day here or there where, because of another tenant in the building testing positive for COVID or something like that, we did have to close so GSA could take action. But we were able to stay open, our intakes were open, and we're really proud that we were able to do that. We have fallen into what we're considering our new normal in terms of staffing, and that is an expanded telework procedure where we have most staff is in the office 3 days a week and working remotely 2 days a week. And it works right now. We hope it will continue to work and be effective. All of our phone calls are answered through our call center without any interruption. So we feel pretty good about where we are in staffing and operations. If you find that something is not happening as it used to, or could be more efficient, please let me know. We're here to make it the best experience for everyone who has to come to the court. A couple of things about NextGen. We talked a lot about NextGen in last year's meeting because it was coming. Well, it came and it's gone, which is a good thing. We successfully migrated to the NextGen version of CM-ECF on August the 9th. Thank you for your cooperation. We had so many good we had such a good outcome because you took a lot of the steps necessary to prepare for this migration. And of course, just a shout out to our incredible staff here at the court, IT and operations, and our ECF Helpdesk, and everyone who made it an exceptionally good transition. Migration. I keep getting corrected that it was a migration and not a transition. But here's a few tips about NextGen. If you change your employment or your firm name, that is something that the help desk can assist you with. So contact the GANB help desk, and the address is in this presentation. Of course, it's also on our website. For routine address changes, however, you have to contact Pacer Service Center. We can no longer do some of those things with your address locally. So you have to go through Pacer for that. If you use filing agents, just make sure that if that person leaves your firm or your employment, you have to be the one to unlink them as a filing agent, or they stay linked to your account. So that is on you to do. For the few people who haven't yet linked their ECF accounts to their Pacer account for the purposes of NextGen, just know that if your username in ECF contained a $ as part of your assigned name, you cannot do the standard linking process. We have to help you, and we'll be glad to help you with that. So if you have not linked yet and your username has a $, contact the help desk and locally, and we'll help you with that. We did leave up our NextGen page on our website. It has all the training materials, the webinars we did, excellent user guides and job aids, and we hope you'll continue to make use of those as we all settle into our NextGen world. Just want to mention a couple of common CM-ECF filing errors. I think overall, I think it's safe to say that we've seen a real good improvement, and what is being filed and the number of errors have dropped dramatically. We spent some time doing outreach to certain lawyers or firms that had regular common errors, and you've responded really well, and we appreciate that. But here are a few things we do continue to see. The incorrect event is used for something, so that the docket entry doesn't match what you're trying to do. So if you will use the search feature on the ECF bar at the top of the ECF page, it will be a huge help to you and cut down on things you have to correct after the fact. If you use the search feature, start typing in what it is you're looking to do, your options will show. and then you'll know you can pick exactly what you're trying to do. And that's especially helpful if what you're trying to do is not a fee-based event and you happen to pick the fee-based event. That's an error, and that's going to cause you some problems as well. So use the search feature, and I think you'll be glad you did. We do continue to see instances where missing documents or just required documents are missing. Most generally either certificates of service or amended summaries of schedules if you've added creditors. Those are required documents. So if they're not filed with your pleading or your document, there will be a deficiency posted on the docket, and that's something you'll have to see and correct. We also have, some number of situations where either the case number or the case name are wrong. Usually for the case number, it's an inverted numbers, or you've used an old case number on a second or third filing. So just make sure your case number, your name are the right people and the right case. Incorrect calendar events hearings is also a problem. So we just ask you to make sure to rely on the judge's available hearing dates that's on the website in one common link and also on each judge's page. And also be sure to always use a courtroom location in your hearing notice and not a telephonic hearing number. And incomplete or incorrect attachments, and that is a problem, probably will always be, just because the nature of what you have to do to file something. But I'll say, for those who've been around as long as I have, if you reach back to the days in the mid-90s when we first converted from, I forget what we were on before CMECF, but whatever it was, before CMECF, when we went to all those trainings back in the day, they just pressed over and over, check your document before you file it. So once you've gone from a word process document to a PDF, it's somewhere in your system, in your browser, in a folder to file. But before you actually attach it, open it and make sure it's the right thing. It will save you so much time and will certainly cut down on the number of deficiencies and issues that you have to correct later. A couple of quick financial announcements. One, we have already sent a public notice about this, but we'll do it again as the time draws closer, and that is that effective January 3rd of 2022, the Atlanta division will no longer handle cash payments. We actually made this change in Noonan, Rome, and Gainesville quite a while ago, but it will happen in Atlanta, and for a host of reasons, including some changes with financial institutions, we will no longer accept cash at the Atlanta division. Of course, we'll accept cashier's checks, money orders, attorney checks, but not cash. And keep in mind that we do have the online payment system now, where lawyers or debtors, represented or not, can make payment through the online system, and that's through PayPal or a debit card. That's been very successful for us, and I hope convenient for you. So please check the court's website for all the details about how to do it. It's very easy, and I think once cash is no longer available, it will be needed even more here in the Northern District. One other tip on financial is that if you do happen to select a pleading that requires a fee and that's an error, you didn't mean to do that, before you take any other action, contact our financial group, and the email address is in the PowerPoint. They often can help with that before you have to take any other action. They sometimes can just remove the fee. So let financial help you if they can. A couple of quick announcements from the bench. The judges have noticed that often in pleadings and motions that are filed with the court, both using voluntary noticing procedures and not, the hearing notice is kind of buried in the document. And I don't think it's anything intentional and nefarious. It's just the way you're putting together your documents. And so the notice really should be first, both in the filing of the document and in the service of the document, so that the parties know, is there a hearing, is there a deadline? They need to know that first. So it should be notice, then the document. So the judges ask that you please pay special attention to that. Also, you've probably received some notices both from our court and from the Atlanta Bar and State Bar and MACBAG that Judge Bezier is going to hold 2 Zoom meetings in November. And these are follow-ups to a Federal Judicial Center survey that he had done several months ago, and you are welcome to attend. The meetings will take place in Judge Bezier's virtual hearing room. The link is on his website, on the court's website, of course, and here in this PowerPoint. And the dates and times are on this slide. And then some other just general news and announcements. We do send out court announcements through the email notification system known as GovDelivery. If you have not signed up for email updates, and I hope most of you have, or all of you have, I urge you to do so. That is our official notification system, and you can do it right from the website. In the middle of the front page is a icon that says email, and if you click on that, you put in your email address, and it's for attorneys, staff, anyone who wants to get what ends up on the court's website under news and announcements. So throughout the year, there are a host of them related to court openings and closings, related to maintenance on NextGen, on general orders that are issued by the court, procedural changes, lots of things. So it's important information, and I think you would all want to get it if you're not already. So please go ahead and sign up for those. And then I've listed here some of them, the more important notices that we issued since October 1 of last year. And in reverse order, October the 15th is when we first announced that pay.gov option that I mentioned just a minute ago. On November the 18th, we noticed changes to the Chapter 13 plan and general orders associated with the implementation of the plan here in our district. On January the 6th, there was an amended and restated general order related to voluntary notice procedures, and that was to clarify and confirm that these procedures apply to all pending cases, not just cases filed after a certain date. In January of this year, we did a general order 44-2021 was entered by the court, and that related to procedures for filing, service, and management of highly sensitive documents. And this was as a result of the SolarWinds and the breaches on government computers and private computers as well. We do not have many instances of HSD documents in this court, but the order talks about how, in the event any are filed or received by the court, they'll be maintained. In March of this year, we did a public notice regarding the supplemental proof of claim form under the CARES Act, and it was Director's Form 4100S. In June of this year, we did a public notice regarding the new required Chapter 11 periodic reports issued by the United States Trustee Program. In June of this year, we did a public notice regarding the Appropriations Act and the new CMECF acts that go with that new rule, and that involves the new hardship discharge provision under 1328I. In July of this year, we did a notice regarding General Orders 45 and 46-2021. General Order 45 is the one that I will say was a significant revision to the procedures related to what unrepresented debtors could file with the court through our electronic filing system. And General Order 46 announced the designation of the panel for complex Chapter 11 cases in the Atlanta division. That has to be updated per the original general order. And beginning in February 1, 2022, that two-judge panel will be Judge Sacca and Judge Ellis Monroe. In September of this year, the 16th of September, we did a significant announcement regarding changes to our website and bankruptcy court hearings. It was a pretty good update that I think and have heard has been helpful for everyone in terms of direct access links to virtual hearing rooms for all the judges, a reorganization of the chambers pages so that the tabs are the same, but the information underneath might be different and will be different as each judge decides to add things or remove things. But the tabs are the same, and there's central locations for all of the virtual hearing rooms. So I think that has proven to be a good change and helpful to everyone. One thing I'll mention about the virtual hearing rooms, you shouldn't really save those, bookmark those. Go ahead and click live to the website links, because if something were to happen and you have a bookmark link and somehow that room location has been changed, I don't know the technical term for that, but you may not get where you want to go. So don't bookmark those links, go to the live links. And then I think our last announcement, public notice that we issued for fiscal year 2021 was the appointment of Ed Saphir as the Chapter 13 trustee, which was a great and happy announcement. Just a couple of announcements for our court. And big changes ahead, I will say that Fred Childers, who is our Chief Deputy Clerk, will retire at the end of this month. I have known Fred since, I think, 1991. I was trying to remember if it was 1990 or 1991. First in our Chapter 13 world, and then working together within the judiciary. He is a visionary who's created opportunities for so many people in every job that he has held. He's managed significant change at every turn of his career. He is thoughtful and he's deliberate and kind. And it's not possible for me to tell you at this time all of the contributions that Fred has made to this court and to the bankruptcy community in his remarkable career. Fred's wife, Maureen, who is an amazing person in her own right, retired last week. So they have great plans together for their next chapter, so to speak. I will miss Fred as a true partner in leading this court, but I know that he will remain in my cherished circle of friends. So who gets to fill his rather large shoes? And that's Vania Allen. Vania will become the Chief Deputy Clerk on December the 1st. Many of you know Vania from her years of practice with the Macy Walensky firm and then in the U.S. Attorney's Office. She joined our court a little more than 3 years ago as Chief Deputy for Operations. Vania brings fresh ideas and energy to Georgia Northern, and I look forward to the great things that she'll do in this new role and working with her to lead our amazing group. And again, I don't know that I can tell you how remarkable this court and the staff has been. They're like that every day, but in these COVID challenging days that we're now going almost into 2 years, they have stepped up at every turn to do whatever we need. And I will always be grateful. I tell people that I will remember a lot of things about COVID-19, but I'll remember how Georgia Northern responded front and center, and it was a good thing. So a couple of other not as important reminders or announcements about GANB. As you know, a couple of years ago, we started sending emails to attorneys and actually letters to pro se debtors regarding missing 1328 statements or financial management certificates. Our goal was to just get as many debtors to cross that line to discharge as we could. That's what we're all here to do. So we started sending out these notifications and probably have sent several hundred in Chapter 7 cases. We started that later, but we have over 43% that got those submitted and got their discharge without any further action necessary, just an email reminder to the attorney and a follow-up from the attorney to the client. It's significant. That's 43% of several hundred that didn't have to file a motion to reopen their case and pay a fee to get a financial management certificate filed. So we're going to continue that. It's a lot of work on our end, but I think it's valuable work when discharge is the prize. And then in Chapter 13 cases, which is where I started this, I have over 1,700 emails that have been sent or letters that have been sent to debtors or attorneys about this. And I don't have the stat on how many, just because I can't do that kind of math, but it's a significant percentage, maybe even higher than the 43% that actually got those documents filed before making it to the show cause level with the court, and then getting them filed before the case was actually closed without discharge. So I think this is important work, but I do ask that you go back and look at your internal procedures and put something in place so that when in a Chapter 7, when that trustee files the no distribution report, or you get the computer generated notice regarding the financial management certificate, which goes out in every case, that you make sure your client has done that and has submitted that certificate. Or when you get my email or the email from the court saying, we don't have it, we need it, that it gets done. And in the Chapter 13 world, once the trustee files that notice of plan completion and final report, you need to make sure that those missing documents are filed, the 1328 and the financial management certificate. And then we can all just do our part to help debtors get their discharge. One reminder that we've said for quite a few times over the last few years is about flattening your documents. And I think that has improved greatly. But I'll just put it out there again to remember that when you are creating a PDF to file with the court, whether it's the plan or any other document, that instead of print to PDF, you should print it to PDF and not save it to PDF. Saving it to PDF for filing doesn't flatten the document or lock it down. Printing it to PDF does, and that will prevent either malicious or just erroneous changes to that document once it gets filed. So flatten your documents, please. And finally, as I always do, I will tell you how great our online procedure manual is. It's a living, breathing document that is updated regularly, and it's on the ECF menu bar under, you'll see the little green eye, and that's the procedures manual. If you click on that, type in what it is you're looking to file, it will give you so much information about the document, the event, exactly how to file the document. It will relate back to federal rules, why we have that document. It's a super helpful procedure manual that's available online, and I encourage you and your staff to get familiar with it if you're not already. So I'll stop before I go to the federal rule changes real quick and just look at my folks here in the room and see if there are any questions that we need to bring up now. Anybody? We're good? Okay. So this year, the federal rule changes for December 1 are few compared to what we've been dealing with lately. And just real quickly, they're pretty technical. Rule 2, and these will all take effect December the 1st, 2021. Rule 2005 regarding the title of the rule is Apprehension and Removal of Debtor to Compel Attendance for Examination. And this is really just a tweak of subsection C because it relates to a change that was made in the underlying sections of some bail statute that at this moment I can't, the Bail Reform Act of 1984. So this is just a technical change regarding Rule 2005. Rule 3007 relates to objections to claim, and A2A will be amended to clarify that special service methods required by Rule 7004H must be used for service of objections to claims only on insured depositories as defined under the FDIC Act. So you'll want to make sure you're following the objections to claim rule section. Rule 7007.1 is the corporate ownership statement rule, and that will be subsection A will be amended to include that non-governmental corporations that seek to intervene, and in addition, stylistic changes were made to subsection B to reflect that some statements will be filed by non-parties seeking to intervene. And these changes conform recent amendments to Rule 8012 related to the federal rules of appellate and civil procedure. Rule 9036 is probably, unquestionably the most significant one for our bankruptcy court purposes. So we're going to spend just a minute on this. Rule 9036 is amended to further the use of electronic filing and notices. It recognizes the court's authority to provide notice or make service electronically through the Bankruptcy Noticing Center or the BNC. And it separates what courts can do with this notice and what parties can do with this notice. So under the amended rule, both courts and parties can serve or provide notice to registered users of the court's electronic filing system by filing documents within that system. And also both courts and parties can serve and provide notice to any entity by electronic means if they've consented in writing to receive that service by electronic means. There's a link to a memo that details the BNC procedures it's very good. It's a very detailed memo, and it'll really explain this in good detail. So I encourage you to read it. We have a link to it in this presentation. Continuing on, only the courts can serve or give notice to entities at an electronic address registered with the BNC that's part of the Electronic Bankruptcy Noticing or EBN program. You know, we have an acronym for everything, but EBN service is only available through the court with this electronic notice. The real authority behind this rule, it empowers the Administrative Office of the Courts, the AO, through BNC, to reach out and contact what they deem to be high volume paper recipients of paper notices. The AO established that at 100 paper notices per month. If you get 100 or more, you're considered a high volume recipient, and you will then be required to have receive your notices electronically. And we at the local court level do not get involved in that communication, but if you establish that as requested, Or as the rule says, if you fail to establish it on your own, the BNC gets to do it for you, or the AO gets to do it for you. Then we are then notified, and that becomes part of your notice from our court. For our court notices, they will use that established email address. So if you are someone who receives 100 paper notices or more a month, you are high volume, and this rule impacts you. So I encourage you to read the memo carefully. And if you have questions, let me know. If it's something I can answer, I will, or if I need to get more detail for you, I'm happy to do that. But this is another in a long line of, I think, gradual changes to make sure that we can maximize electronic notice, save money for the judiciary, and just become more efficient in general. So Rule 9036 deserves some attention. The only form change this year, which is kind of amazing, so we've had so many, is official form 122B. That is the Chapter 11 statement of current monthly income, and it is amended. We have a little picture to show where it's amended, to confirm that it does not apply to subchapter 5 cases. And then one thing we want to preview a little bit, and there'll be much more information this month about this, something we're excited about, again, involving electronic noticing, is something called Debtor Electronic Noticing, or DEBN. This is a well-established program now throughout the judiciary. Many courts use it. I think, if I'm not mistaken, Georgia Middle might already use it, and some others within the circuit. But it enables debtors, whether represented or not, to receive court-generated notices and orders through the BNC process electronically. It is voluntary, and it's something we initiate locally. Debtor would sign a consent form we'll have, which explains DEBN, and we start the process for them. Once that is sent to the BNC will send the debtor a confirmation email to make sure everything's working right. And it's the way the debtor would receive court-generated notices and orders. Our information that we'll share with you later throughout the month has much more detail about what happens if there's a bounce back email and the debtor reverts back to paper notices and things like that, or they can opt out even after they've started. They can say, no, I'm not happy with this. I'd like to go back to paper. It's a voluntary program. But I have heard through many sources, and we've visited with many other courts about this, that it's very successful. So when the debtor receives notifications electronically, whether it's an order or a notice, it's in a PDF format, and there's no cost for them to view the PDF. They can look at it as many times as they want, download it, save it, print it, whatever they would like to do. So we hope to go live in early December, and much more information about DEBN will be coming out this month. So any questions from our chat that we need to address that you guys haven't done? Okay. Now at this point, we can open for questions that you may just want to ask aloud. What you'll need to do, if you will, is, excuse me, please raise your hand using the feature on your Zoom platform, and it'll prompt you to unmute your microphone, but we'll also remind you when we call on you. So if there are any questions, now would be the time.
We have Janine Treese.
Janine, will make sure you unmute. Janine, can you hear us? Janine, do you want to make sure you're unmuted? There you are.
Okay. Hey, everybody. You may have covered this, and I may have looked away for a second, but will the debtor's election of the
EBN?
Will that be annotated somewhere on the docket so that you know that the debtor?
Yes.
Okay.
Yes, it will be notated that they are a DEBN participant. Good question, Janine. Thanks. Anybody else? No? Great. Okay. I think you just want to get to a parade. I think you all want to watch or go to a parade. I just have a couple of quick announcements and we will be finished. I asked the four main bar organizations if they had anything they wanted us to share. The State Bar is having an evidence and trial skills CLD on November the 10th at noon. If you visit their website, you can register for that. That will feature Chief Judge Higginbotham. The Atlanta Bar Bankruptcy Section will have a holiday party on December the 18th at 5:30. And again, if you'll go to their website, you can register to attend that event. iWork is having a holiday party on December the 14th with details to follow. And MacBag is holding a virtual program on December the 18th at 4 p.m. And the topic is the realities of compassion fatigue, techniques for prioritizing and enhancing mental wellness for attorneys. I think it sounds like an excellent program, and there will be details about how to register and get the Zoom link for that program. Just our last slide are the general announcements I seem to make every year. One is regarding weather, since we're moving into winter. WSB and the court's website are the official notification sites for any court delayed openings or court closings. So please rely on WSB and the website. This is another important time to make sure you're registered for the court's emails, because if we put a public notice out, you're also going to get an email alert. The construction around the Russell Building continues. It was sort of this is the formerly Spring Street, now Ted Turner Viaduct replacement project. And it was pretty much no activity for most of the first year of COVID, but they have started working again, and now we're told it will be finished sometime in 2022. We'll see about that. Recording of this meeting and the PowerPoint will be posted early next week. And I'm sorry, somebody's trying to tell me something that I don't know.
Karen King just made a comment that the MacBag meeting is November 18th, not December 18th.
Oh, I'm sorry. Thank you for that. I apologize. I knew that. And I'm so glad you said it, because we don't want to mislead anyone. This is a great program. So the virtual program for MacBag is November the 18th at 4 p.m. And I'm beginning to think that the Atlanta Bar Bankruptcy Section Holiday Party is also November the 18th, because I think they're on the same day, but at different times. So before we post the PowerPoint, I'll correct these dates or make sure they're correct. I think the Atlanta Bar and the MacBag events are both November the 18th at different times. But my apologies. I was thinking holiday and I guess thought December. So thank you for that clarification. We don't want to put out that information. Anything else? Anybody? Great. Well, I thank you so much for attending our annual meeting. It's always great working with you, and I hope we'll see a lot more of each other in person in 2022. Wishing you and yours a happy Thanksgiving, and let us know if we can be of assistance. Thank you.